The item for delivery of order, item number 5, bail application 383 of 2024.
Petition dismiss.
Mike.
Item 1, Lordship.
Ah,
Lordship, today I filed additional affidavit, Lordship. The second time application, Lordship, the fixed on Monday, Lordship.
on the request being made by Mr. N. Ahmed, Learned Counsel for the accused, rescission is the matter on
Monday, Lordship.
Monday. 10.
Deeply obliged. Yeah, Lordship, item 40 of 21, code number 21. Lordship, the engaged counsel is out of town, Lordship.
pardon,
Engaged counsel is out of town, Lordship. CD was called for in this matter.
item number.
40 of 21, code number. Is there, Lordship.
Who is the engaged counsel?
M. Muzammil.
M.
M. Khan.
M. Ahmed.
M. Ahmed.
What is your name?
S.K. Chhatri.
Mr. So Learned Counsel appearing on behalf of Mr. M. Ahmed, Learned Counsel for the applicant, press for listing the matter on
On Monday, Lordship.
Monday. Okay, fair.
With the consent of other side. Informant is there.
Okay, with the consent of other side. Who is the informant?
I take the concern. That's why he's not present.
Okay.
Problem.
I beg to mention item number 33 of code number 21, Lordship. The case diary is there, Lordship. Lordship, may I pray for fixing it on Monday? I could not contact my client for the last 1 week, Lordship. So I'm not in contact with him. So
Item number 33.
Three. Yes, Lordship. 3.
Your name is not there.
Yes, Lordship. I have filed the case. The case is on was this is showing the name of Digogo and I Waterbull, but in the I have filed the wakalat number also. The case was filed by me, Lordship. Unfortunately,
So Learned Counsel appearing on behalf of. Whether your Ukalatnama is there?
yes, Lordship. Lordship, I filed the case.
Press for listing the matter on Monday. There is allowed. Okay.
Obliged, Lordship.
Wait, please, Your Lordship.
Hmm.
With due consent of other side, I beg to mention item number 4 of the daily list. Matter be urgent for a week, Your Lordships.
Mr.
S.A. Borguya.
S.A. Bormoya, Learned Counsel appearing on behalf of
Mr. A.W. Aman.
Mr. A.W. Aman, Learned Counsel for the
Respondent, Lordships.
respondent number,
Sole respondent, Lordships.
sole respondent with consent from the other side. Did you obtain consent?
Yes, Lordship.
Press for listing the matter when?
After a week, any date may.
On 18 June.
18 June. Okay.
Deeply obliged.
Items from code number 15, promotion bail application. Item 2.
My lord.
Yes.
My lord, in this case, earlier the lordship rejected our bail applications.
What
On
is
the-
the ground for filing?
On
the second
that day, my
application?
lord, on that day, actually, I could not bring on record one order passed by this noble court.
Hmm.
It is page 27. Page 27, my lord. And here, your lordship after purging of the city, again rejected the bail of the some all the main accused persons and allowed some persons who are not involved in the stealing the articles. Your lordship can see page 29 paragraph 5 of that order. That's 5, my lord. Yes, sir, prisoner has produced the case diary before this court and submit that IO has collected sufficient materials against the applicants, namely Ashikul Haq, Indazul Haq, Sohidul Islam. So they are well rejected. I am Ashikul Islam, my lord. So I was, my bill was rejected because on the CD, it has been mentioned that stolen article first stored in my Godam, whereas I am a labor, I have no, anyhow I am managing my family, my lord. So my lord, CD may be called for again.
No, on the other day, we have examined the matter.
Yes, yes, yes.
And Mr. B. Sharma,
Yeah,
the
yeah.
learned additional PP on the other day pointed out that as per statement of some of the accused, articles stolen were stored in his house, in
Yes.
his Godam.
Actually, it should be article Haq. I am Ashikul Islam, I am a labor.
No, we, sir,
So that is why my lord, you lost fixed since you lost already rejected my bail applications. Fix the matter on 12 or 13. 12 or 13, let the city come and I will clarify the matter.
no, you see, we cannot interpret the materials available in the case.
Otherwise, my lord,
Your
you lost
name
me.
there-
Yes, my lord. Otherwise, my lord, you lost me. Fix out 13, it done 53 days. 60 days is mandatory period, my lord. 17 is the on that
No,
down it may be fixed, my lord.
No, Mr. Council, you see, second bail application is maintainable only change of circumstance.
No, yes, my lord.
Then
my lord. But
what is the
I,
change of circumstance in your favor then?
it is correct, my lord.
Hmm?
So let me 60 days mandatory period is 60 days, my lord. I am now completed 46 days today, 45 days
Heard
today.
Mr.
Yeah,
Jayahan, learned
13 it may be fixed, my lord. It will
accused
be
and also heard Mr. P.S. Lawcourt, learned additional PP for the state respondent. This application under section 439 says preferred by accused Asikul Islam, who has been languishing in Jailazat in connection with
20.
Hazara PS case number 85 of 2024 under section 407 to 79 IPC since 22/4/2024 for grant of bail. Further, having heard the submission of learned advocates of both sides, it is provided that Mr. Lawcourt shall furnish the case diary before this court on 13.
13 it was under 53 days will from our.
For bail hearing,
Hello.
item number 6.
May it please your lordship. This matter, your lordship, on the last day before yesterday, your lordship, they were supposed to file the evidences of 3 witnesses. I have filed it. It is on record. Your lordship. The matter relates to your lordship. NDPS, commercial quantity of Odicil, cough syrup. The 3 grounds that I have taken, your lordship, now. No, that is on, it has been brought on record.
Yes.
So this is your lordship. Here I have taken 3 grounds. Basically, number 1, your lordship, is that the first ground on which I rely was that when the main accused was arrested, he has given my name. So this is basically the
So co-accused statement.
co-accused statement. On the basis of co-accused statement, I was arrested. Number 1. Number 2 point that I would like to point out is with regard to the evidences on record, the evidences of the witnesses. All the witnesses, mainly search and seizure witnesses and the independent witnesses, have, your lordship, no way specifically, your lordship, proved that I was arrested on a particular place, and as well as the particular cough syrups have been recovered from me. the only witnesses which has been examined for the search and seizure, they have stated that the recovery was made earlier from the co-accused who was arrested. And with regard to the evidences in regard to this petitioner, there was no specific ground to show that the cough syrups were recovered from me from a particular place, or like there were so many discrepancies in these statements. These are third point, your lordship, that it is a technical point. Your lordship knows that if in a particular case when there is a remote chance of conviction, then your lordship, the person is entitled to bail. This is, and the last point that I would require is that he was arrested long back, that is, your lordship, about nearly 2 years, 1 year, 11 months ago, your lordship. 1 year, 11. These are the basic points. So now I will take your lordship for a moment to the FIR, your lordship.
Is it the second application?
This is the second one, your lordship. The first was rejected by your lordship. At that time, the evidences, all these evidences were not there. Therefore, I come up with the second. Your lordship's order is there. Your lordship would like to see the order, that is at page 58. Page 58, your lordship. And while passing the
You have also submitted that there is a remote chance of conviction. Is
lordship,
it a ground? Is it a ground to consider at this stage?
because your lordship, there is
So
a,
how many witnesses cited in the search sheet?
there were 11 witnesses search sheet,
11.
cited in the search sheet,
How
out of
many
which
witnesses-
9 have already been
How many
examined.
witnesses examined? 9.
9. All the witnesses of independent and search and seizure witnesses examined, except I think 1 or 2 police witnesses are not examined. All the others have been examined, including the, I think, FSL person, your lordship. These have been examined. Now,
So
from where,
is it not premature to arrive at a conclusion that there is remote chance of conviction?
With-
Because it is well settled that in the cases under NDPS Act, even the evidence of police official also can be relied upon to record a conviction.
that is true, your
Provided
lordship.
that.
Two of the
say
police
by a
officers have given evidence. 2 of the police officers have given as witness, evidences have been recorded.
Hmm.
There also, your lordship, one of the officer has only stated with regard to the co-accused, not with regard to this petition. 2 persons were arrested in 2 different places. One person, the co-accused, was arrested in another place, and on his, your lordship, information, the present petitioner was arrested in another place at another time.
Hmm.
And the second one, your lordship, from where the evidences I have seen, there is, if none of them has seen that something has been recovered from him. They have the places where,
Mr. Mannan, you see, the accused is also serves under section 29 of the NDPS Act.
absolutely, lordship. But there has to be some kind of a nexus in that case.
Definitely.
your lordship. There has to be some kind of a nexus within the 2 persons, that they, no doubt, the co-accused has named him. The lordship, then again, Tufan Singh will come, whether that will be applicable or not. That is a separate aspect. Now here, your lordship, I have 1 or 2 judgments where it says that if there is a very remote possibility of conviction, then bail normally is to be given. That is one.
Is it in the cases under NDPS Act?
Yes, NDPS, NDPS. I'll just hand over a copy of the. It divided. This was a 2020 judgment of the Honorable Supreme Court, your lordship. I'm not reading the facts. I'll just take your lordship to paragraph 11. Or if your lordship can take a paragraph 10, last 3-4 lines. Your lordship.
Hmm.
From there, I'll start.
Hmm.
3 lines. However, your lordship,
Hmm.
at this stage, it cannot be said with certainty whether he was aware that drugs were being smuggled on the ship or not. Though the allegations is that he made such statement to the NCB under section 67 of the NDPS. So this is under the NDPS. Now, your lordship, para 11. At this stage, without going into the merits, we feel that the case of the applicant herein is totally different from the other accused. Reasonable possibility is there that he may be acquitted. He has been behind the bar since his arrest on so and so for 2 years. And he's a young man, about 25 years. He's a so and so graduate. Therefore, under the facts and circumstances of this case, we feel that it's a fit case wherein the appellant is entitled to bail because there is a possibility that he was unaware of the illegal activities of his brother and the other accused members. The only thing, Your Lordship, I point out is that reasonable possibility of that he may be acquitted. This was only, it is a small judgment where the court has given that on 2 grounds. Number one is that there is a very remote possibility of his conviction. Secondly, was that they felt that he may not have the knowledge about.
No,
These are the
whether
two points.
in that case, all the witnesses cited by the prosecution have been examined.
With regard to Your Lordship, I don't know in this case whether all the prosecution witnesses were examined or not.
Then how can we
But
apply the
from the
16
fact that, Your Lordship, I have just given the witnesses. I'll cite 1 or 2 witnesses which will show hardly anything against him.
Hmm.
Hardly anything. I have annexed those. Your Lordship. The first PW starts from page 52. Page 52, Your Lordship will finally see. From PW, page 52, PW1.
Yes,
It has got that, yes. I don't know, accused so and so and so and so. I could not recognize the accused person if they are on top. The incident occurred about 1 year on the day of occurrence and about so and so. I was going to Pamari market for loading of my vehicle. While I was proceeding, I have seen a group of persons on the road near to Pamari. On being asked, I was informed that cough syrups were recovered on the place of occurrence. Thereafter, I went to the market, loaded the vehicle for my business and returned to my house. So basically, he asked someone, told him. This is basically, I'm not reading everything, Your Lordship. So this is it. But he was ultimately, this person has been declared as hostile. So I'm not reading that. Next, Your Lordship, will kindly see the next one. This is PW3, page 54. 2 and 5 I have given separately. So this is PW3, Your Lordship. Here, Your Lordship, I don't know the informant. I don't know the accused so and so and so and so. The incident occurred about 1 month ago at about 7:30 a.m. On the day of occurrence, while I was returning home, one quarrel had taken place. On the next day, morning, police visited my home and took signature. Under these circumstances, Your Lordship, it is very difficult for conviction. Then Your Lordship, PW4, next page. At about the same thing has been stated that manual so and so, so and so. The incident occurred 1.5 years ago at about 7 p.m. On that day, while I was returning from Tupamari market, I have seen a lot of gathering at so and so. I have not visited the place of occurrence, but I have heard that police have recovered some cough syrup bottles. On the next day, police visited our village. Police found me on the road and took my signature on the paper. I was not shown any articles. Police has not recorded my statement. I know the accused person as they belong to my village, so and so, so and so. So these are, Your Lordship, statements given by witnesses, and Caesar witnesses and independent witnesses. Then Your Lordship, the police officer, this is at page 56. This is the police officer. He is SI, Mirel Ahmed, some SI. The incident occurred in month of July, so and so. At that time, I was posted at so and so PS and so posted as OC. On the next day of occurrence, after receipt of notice, we were waiting at RCC bridge at Nagarbera, as so and so, so and so, so and so. Also waiting along with me, we have intercepted one Glamour motorcycle which was coming from the side of Tupamari. 2 persons were riding the motorcycle. We searched the 2 persons and found 11 numbers of cough syrup bottles, 1 mobile handset, so and so. The above articles were seized and brought to the police station. The accused persons who were present in the dock today are the person from whom the articles were recovered. Now in the cross-examination, I was performing duty on the eastern side of RCC bridge. There was a shop of stationery goods, grocery, tea stall and bus stoppers on the eastern side of the RCC bridge. There were shops and masonry clothes on the western side bridge. If any incident take place in the bridge, the people of the shops will know that. So and so between distance between our PS and bridge is 300 meters. It takes about 2 minutes to reach the bridge by car. PS, I have recorded my statement, my 161 statement. I have stated that 2 persons are coming in the motorcycle. And 161 CRPC statement I stated regarding finding the bottles, but have not stated finding 11 numbers of bottles. As allotted duty by the OC on that day, it is not a fact that no bottles were recovered from possession of the accused persons. It is so-and-so statement was recorded the same. Neighboring people of the place of occurrence were called up. I cannot recall the shop owners who came to the occurrence. It is not a fact that the motorcycle was bought by the OC from bus stand and that the accused persons were not riding the motorcycle. Generally, bikes and cars were parked near the bus stand. So here I am reading this because of the fact that this was in another place. This was in Nagarbera. This was in Nagarbera, whereas the present petitioner was in Tupamari market. So these are two different places, absolutely. Absolutely two different places. Here, he has stated with two persons in a motorcycle. In the other statements, there was no such 2 person, only 1 person was apprehended. In the FIR also 1 person was stated. And the other person was from Tupamari in another place. So this does not, your lordship, gel with the evidences of the other witnesses. Then, your lordship, I have given the other witnesses in the additional affidavit they have filed. Here, witnesses 7, 8, 9, 2 and 5. 7, 8, 9, that page 68. 7. This is with regard to, your lordship, why I am saying that this PW7, your lordship, is the junior scientific officer, FSL. So I am not reading that. He has, I have no allegations against that. Page 70. He says, I know the informant so-and-so, SI so-and-so, I know accused Mominul Islam. This is the main co-accused. I do not know accused Sadek Ali. The incident occurred so-and-so. On that day, I was posted at Nagarbera. On the day on 20th, Nagarbera, Mirel Ahmed asked me, stated to me that he has some information and asked me to accompany him for checking. We started checking vehicles at RCC Breed, eastern side of Nagarbera Bazaar. CC Kumar, Basumatari, so-and-so were present along with us on this day. Armed battalion party were also there, but I do not know their names. During check-in, we have found 1 motorcycle coming from Tupamari side with 1 rider. On being signaled, the rider stopped the motorcycle and the same was searched by the officer in charge and so-and-so. During the search, 12 bottles of cough syrups were found in plastic bag. The rider of the motorcycle was Mominul Islam. So they have only found Mominul Islam. I'm not reading. Then, your lordship, page 72. These are all police witnesses. I know informant so-and-so. The incident occurred on so-and-so. On that day, I was working at Nagarbera PS as UBC so-and-so. I know accused Mominul Islam from the day of the incident. I do not know accused Sadek Ali. On the day, I was in the ready party of so-and-so. On that day, at around 2:33 p.m., OC asked us to accompany him. CC Basumatari so-and-so and other staff along with went to Nagarbera market and started Naka checking near the RCC bridge. During checking, along with other vehicles, 1 motorcycle Glamour was also checked, which was coming from Tupamari side. OC informed us that some intoxicating articles were recovered from the motorcycle. Accused Mominul Islam was driving the same. So these are this. And the yesterday we have filed the final one. Right. Here, your lordship, 2 and 5 have not been annexed. So we have annexed PW 2 and 5. So 2, your lordship, will find page 77. Same thing, your lordship, they don't know Sadek Ali, Mominul Islam, only Mominul Islam has been taken.
Okay, yes, Mr.
Basically,
Locker.
this is my fact, your lordship. From this evidences, if your lordship feels that there is hardly any chance of conviction because there's no specific, nothing is there against the accused. Though 2, 3 witnesses say that somebody has heard about commotion, some recovery was made, but nobody has seen, and all the police has taken the signatures from their home or a village somewhere far away. So these are the only evidences. Mominul Islam, I am not against. I am only praying for the petitioner here, Sadek Al. There is nothing, your lordship, with regard to this from the evidences of it. I am not going against anything else. FIR, your lordship, then the evidences on record. These two things. If your lordship correlates, then your lordship will not find anything else.
May I please, Lordship? Also, in this case, Lordship, there are 11 witnesses, and out of 11, 7 witnesses and 9 witnesses have already been examined, Lordship. And it is not like that, Lordship, nobody has stated nothing. It is the PW 2 or 6 and other witnesses, one more witnesses has stated, Lordship, that Lordship, they have shown the gathering in front of the house of the in front of Sadiq Ali, and thereafter when they came there, they asked that some article and substance, narcotic substance has been recovered. And in that case, Lordship, though he has also stated, Lordship, that I have not seen, but on the next day, my signature was put in the seizure list. But the IO, Lordship, IO statement, and I have gone through the statement of 161 statement of the other remaining witnesses, Lordship. And in that statement, Lordship, Mirel Ahmed, SI, Lordship, his statement is important, Lordship. He has stated in his 161 statement, Lordship, the entire fact, Lordship. And thereafter, Lordship, the IO statement, Lordship, both has implicated this person, Lordship. And it is not like that, Lordship, as the seizure witnesses has not stated anything or directly, they have not directly implicated the accused persons. So he will be released on, he will be acquitted, Lordship. It is not like that, Lordship. Because, Lordship, the witnesses of the IO is also vital, Lordship. There are some judgment, Lordship. Today I am not having that judgment. I was searching in the mobile, Lordship, that Baldev Singh judgment, Lordship. In three is a Lordship judgment, Lordship. Baldev Singh versus State of Haryana, Lordship, 2015 judgment, Lordship. In the here also stated, Lordship, that IO statement is also required, Lordship. And Lordship, as the IO is not yet examined, Lordship. So, Lordship, at this stage, Lordship, he should not be released on bail, Lordship. Or mainly only because of that, Lordship, 7-9 witnesses has been examined. And, Lordship, out of them, Lordship, seizure witnesses has not directly implicated, though they have implicated, but they have not stated, Lordship, that I have seen that part articles recovered from that specific word is not there. Only because of that, Lordship, they should not be released on bail, Lordship. And there is, Lordship, as there is section 37 is also there, Lordship. And the section 37 is also there, Lordship, they should not be released on bail, Lordship.
So where is the statement of 161 statement of?
That I have checked my Lordship in the LCR, Lordship. I have checked my Lordship. They have directly implicated, Lordship.
Reserve का order. Heard Mr. Esminal, learned counsel for the accused, and Mr. P.S. Locker, learned medicinal counsel for the accused.
We have also annexed the 161 statements.
Argument concluded, order reserved.
Item 7.
Lordship.
May I please, your lordship? This is this third subsequent bail application of the petitioner. If my lord may permit, I may take your lordship to the first bail application which was rejected at page 55. And the relevant portion is at page 56. It starts at page 55, last para, my lord. This was the first bail application with a direction. For the above stated reasons, the learned trial court is directed to streamline the proceeding expeditiously, as the accused person cannot be detained indefinitely without trial, depriving the right to speedy justice, preferably within a period of 3 months from the date of receipt of this order. Look, 3 months, what we had got in the first bail application, which was rejected. Paragraph 13, the prosecution NCB shall pursue the proceedings promptly in every step as per orders of the learned trial court to be passed from time to time so as to avoid unnecessary adjournments. And my lord, liberty was given to us to file at the appropriate stage, paragraph 14. My lord, now, next was dealt with by your lordship, my lord, at page 57 by the order dated 18/10/23. We prefer the second bail application after 5 months and 17 days. Earlier, it was 3 months time was granted to us. We preferred the bail application after 5 months and 17 days. It was rejected, my lord. Again, your lordship directed the trial to be concluded within 3 months. At page 62, my lord, paragraph 17. Page 62, paragraph 17. Your lordship got it, my lord, preferably within a period of 3 months. But thereafter, my lord, what has happened, my lord, may kindly come to page 51 once. I will explain what has happened in the trial court and where do we stand right now in the trial. I am conducting this trial, my lord, in the trial court.
How many witnesses have been examined?
Yes, my lord, out of 10, 3 witnesses have been examined, out of which 1 has been deferred. For our application under 231, because we wanted to examine the independent witness along with the seizing officer, because they were related to the same transaction. And I will take your lordship to the relevant facts. What prompted us to file that application under 231, which was allowed by the trial court.
The issue before the court.
Yes,
You
that
there
was
is
allowed, my
still
lord.
here.
My lord.
Why you have filed that petition? That is not the issue before this.
No, my lord. That I'm just apprising your lordship, my lord, what has happened in the trial court. My lord, kindly come to page 51, my lord.
Page 51, yes.
Yes, my lord. These are the list of witnesses.
Huh?
My lord, witness number 1 was examined after the first bail application was rejected on 1923. Thereafter, my lord, at serial number 4, the seizing officer was called on 3 and examined on 3/11/23. And my lord, may kindly come to page 68 once. 68. Well, second para, Shakil Ansari, who is the seizing officer of this case, has been examined as PW2. Learned counsel appearing for the accused Robindra Roy in Guntan has filed petition so-and-so praying for adjournment of the cross-examination of the seizing officer on the ground that unless the independent witnesses are examined and seizing officer is cross-examined, then the accused person will be prejudiced. And in support, my lord, we also refer to a judgment. And the finding is at page 69, my lord, next page. On of the trial court, my lord, learned trial court, on consideration of the submissions of both the parties, prayer for deferment of cross-examinations of the seizing officer is allowed till examination of the 2 independent witnesses, namely so-and-so, so-and-so. After examination and cross-examination of the 2 independent witnesses, cross-examination of the seizing officer will be recorded. Well, now these independent witnesses were not produced for 7 dates, my lord. And a period of 8 months has elapsed after the rejection of the second bail application. We did not file any bail application immediately after 3 months, although it was indicated by your lordship that preferably within 3 months. But we waited for 6 months. Then, time and again, my lord, the independent witnesses could not be produced, my lord, and they belong to those independent witnesses, my lord, belong to the same locality or where the NCB office is located, my lord. Same locality. My lord, at page 51, my lord, at page 51, serial number 6 and 7, the address is provided, my lord. Resident of serial number 6, Bitupon Boro, resident of Upper Chachal, PS Dispur, and Suman Teron, New Chachal. And my lord, the office of the NCB at page 18, my lord, it is indicated, page 18. At page 18, my lord, the address of the NCB office is also indicated as Chachal. So, my lord, my point is, my lord, these independent witnesses who were throughout present at the time of interception during COVID period, my lord, and the truck was intercepted far away from the place of seizure. These independent witnesses were material for the defense to cross-examine in the same light as that of the seizing officer because they were part of the same transaction. and which was allowed. The prosecution did not prefer any appeal or revision against that order passed by the learned trial court. Now, for consecutive dates, these independent witnesses remained absent.
No, is it a ground to grant you bail?
My lord, at best, I have gone through a recent order which was passed by my lord. And my lord has dealt with such an issue.
Hmm.
At best, my lord has also granted a day-to-day trial
Hmm.
in the case Prabha Shankar Tiwari, which is aptly precisely, my lord, that similar to that of our case, of this petitioner, my lord. In that case, my lord has granted day-to-day trial, my lord. And it is only a matter of 8 or 9 witnesses, my lord. And if we get the privilege of day-to-day trial, my lord, the trial can be completed
No,
within a
that's all
period
right.
of 1 month.
We have no hesitation to pass such direction, but the thing is that recently Supreme Court has, in the case of Allahabad High Court versus State of UP,
My lord,
there it is stated that unless extraordinary circumstances is shown or special ground assigned, court cannot grant such pass such order.
yes, my lord, my lord, that judgment
So,
was referred here, my lord,
At
and
this
despite that,
stage,
my
we
lord,
cannot ignore that observation made by the Supreme Court also.
yes, my lord.
Mm.
My lord, and in that light, my lord, the issue was again discussed by a coordinate bench also
Mm.
because of the deficiency of the courts
Mm.
so far as NDPS trials are concerned.
Mm.
And my lord, there is a prolonged incarceration of around 4 years, my lord, now.
That's all right, but
4 years, 11
why
months,
then,
22 days to be precise, my lord.
uh,
And the 7 witnesses, my lord, will take another year or so, my lord. If not less, my lord, because the pace in which the prosecution is proceeding, my lord, 7 more witnesses are left, 8 more witnesses are
no,
left.
for that purpose, special court is required.
Yes,
But
my lord.
presently, the additional district judges courts have been functioning as a special court.
My lord, designated.
So NCB is also ready to establish the court, but
My
the state failed to provide any infrastructure.
My lord.
What to do?
My lord, but in case of Prabha Shankar Tiwari in the month of April, my lord has given day-to-day trial, my lord.
That's all right, but at that point of time, that judgment has not been referred.
My lord, it was
It's
referred.
a Allahabad High Court judgment.
Yes, my lord, it was referred. High Court Bar Association, Allahabad.
There.
Yes, my lord.
Is it referred?
In Prabha Shankar Tiwari, my lord. Passed by my lord, my lord. Your lordship. I've gone through the judgment.
I don't know whether that issue was pointed out or not at that point of time.
Well, this was referred and it was also pointed out, my lord. It has been
That's
discussed.
all right, but merely because rightly or wrongly one order has been passed,
My lord.
whether same benefit can be given to you. Supposing we have wrongly passed that order.
Yes, my lord.
Yes, Mr.
Lordship, in this case, Lordship, please note down some dates which are relevant.
Hmm.
Lordship, the case was split up on 9/5/2023.
Hmm.
Charge was framed on 31st July 2023. Then first witness was examined on 1/9/23. Thereafter, on 3/11/2023, PW2 was examined partly.
Hmm.
But the counsel for the accused, Ravindra Roy, another filed petition on the ground that the independent witness should be examined first. Thereafter, on 1/12/2023, one witness was present,
Hmm.
but he could not be examined. Partly examined, but one accused cross-examined.
Out of this 5 and 7.
Lordship.
No, 6 and 7. Ritupon Boru and Suman Teran.
No, Lordship, may please to see how the accused are taking deferring the case. Yesterday case was fixed. Lordship will be pleased to see. I am reading out the order. Learned LADC for the accused Sukurali and learned counsel for the accused Ravindra Rai and Guntun Roy are present. 2 numbers of witnesses are present, but their evidence could not be recorded as the learned counsel for the accused Ravindra Rai and Guntun Roy has filed a petition being number 151824 praying for adjournment today, showing ground that some urgent matter are fixed before the Honorable Guwahati High Court. Seen the petition, heard the counsel for the consideration, prayer is allowed, issue fresh summon to so and so. This is the Lordship, the way
Hmm.
the accuser lordship seeking time loss. On ground that witnesses are present, but they could not be examined because independent is not there. They will
Sir,
examine.
does say you cannot take this benefit.
No, my lord, actually what has happened, my lord, yesterday, we received a phone call from the court, my lord, that your lordship will take up the matter at 12:10. And I was keen to take up the cross-examination yesterday itself. But because I received the phone call, I was of the view that the matters will be taken up after 2 p.m. So I was there. So once I received the call, my lord, I was here for the bail hearing, my lord, yesterday.
Who informed
Yesterday
you?
I was present, my lord. My lord, I received one of my juniors received a call that your lordship will be taking up the matter at 12:10 p.m. my lord. Which is why, my lord, I immediately came before this court, my lord, to attend, and I instructed my juniors that let the chief examination be recorded, and if time permits, I will surely attend and cross-examine. In the event I am unable to reach, then you people carry on, or the cross-examination may be deferred for tomorrow. We will cross-examine tomorrow. So that was how I had instructed my juniors.
Okay,
And the prosecution yesterday, my lord, they were unwilling to record the examination in chief in my absence, because in case I am not unable to reach within time, then in that case, my lord, the cross-examination had to be deferred for 1 day. Not I specifically requested, my lord, let the chief be
When
recorded,
the next date is fixed.
Next date is 19/6/2024.
my lord.
Okay, Mr. Kyle, do you have anything to submit here?
Lordship, first contraband was seized from the possession of the present petitioner. There is no delay on the trial. Even if the trial, Lordship, Gurvinder Singh is there, then Lordship has seen the previous orders, how the accuser carrying out the trial, Lordship. In each and only in January, probably witness was not present in all the.
Window thing, which judgment you were referring to?
Lordship, Gurvinder Singh, Lordship.
Guruvinder.
Lordship. I'll supply the copy, Lordship. Then Lordship in Vinod Vizina in the month of April, Lordship passed an order. In that judgment, Lordship has taken consideration all the judgment passed by the Honorable Supreme Court and our High Court. And here, Lordship, trial is not delayed due to the prosecution.
My lord, exactly the trial is delayed by the prosecution. The case record is here, my lord. I will take your lordship to the various orders, my lord. If your lordship permits, I will show from the orders, my lord, that how the trial has been conducted. And I am very diligent in my approach, my lord, before the learned trial court. I said that I have a right to cross-examine the independent witnesses along with the seizing officer. Now, thereafter 7 dates elapsed, the independent witnesses could not be produced. My lord, is it my fault? I put this question to myself, my lord. Is it my fault? I can give the and the adjournments are given 36 days, 32 days, 40 days, my lord. These are the subsequent dates of evidence. Even then, the independent witness did not turn up. I will show your lordship from the relevant records which are there in the court itself, my lord. But kindly peruse after 3/11, what has happened? I can explain, my lord. After 3rd of November, how the trial has proceeded, I can specifically explain from the order sheets which is there in the court,
Okay, I will say.
my lord.
And Lordship, yesterday's order of plea is
And
not
my
on
lord-
the record.
One more thing, my lord. After 3/11, 1/12, at 12:30, the prosecution informed the learned trial court that today the witnesses are not coming. So I and my junior left the court. At 3 p.m., I got a call. I received a call from the court saying that the witnesses have come. Are you in a position to come to court? I said I will take at least 1 hour. I did not say no. I said I will take at least 1 hour because I'm far away. Then on the instruction of the court, the learned junior informed me that the court has the prosecution is informed that you can cross-examine the witnesses on the subsequent date. Let the chief be recorded today. And if you are unable to come, we will postpone the cross-examination for the next day at 3 p.m. my lord, after 12:30. And I could not reach my lord at within 15 or 20 minutes because I was far away. And thereafter, my lord, that witness has never turned up. And my lord may record my submission, and if required, a report may be called for in this regard. This is what has happened in the trial court. I can say this because I myself is conducting the trial.
Okay, we'll see.
Locks.
Third, Mr. Estes, Learned Counsel for the accused, and Mr. Sika, Learned Standing Counsel for the NCB. Argument concluded, order is that
Item 8,
Yes. Here, my lord, circuit submitted.
I'm on interim, my lord. Here two diary was called for, my lord. Here two diary was called.
Diary call for, you are seeking bail in which case?
28. There was a.
28 case na,
Bhamagur 28 or 30.
29 and 30.
29 and 30, sorry.
We are seeking bail in 29.
Oh.
29 charge sheet submitted.
No,
there's Ranjit Singh and
Yes.
3 others.
yes,
So you were on interim.
yes, we are on interim now. There are 4 accused, my lords. All are on interim manner. The land dispute, my lords.
So we will extend the interim bail.
My lord, will
You
appear,
go and approach the trial court.
my lord.
Heard Mr. Buibara, Learned Counsel for the applicants, and also heard Mr. B.V. Gogoi, Learned Additional PP for the state respondent. This application under section 439 is referred by 4 accused, namely Ranjit Singh, Rajiv Singh alias Rajiv Kumar Singh, Sanjit Singh, and Pawan Kumar Singh alias Pawan Singh, who are apprehending arrest in connection with Bhamagar PS case number 29 of 2024 under section 323, 307, 354, 379, 294, 506, 34 IPC. It is to be noted here that above noted case has been registered on the basis of 1 FIR lost by 1. Where is the FIR?
FIR is page 13, my lord.
On the basis of 1 FIR lost by 1.
Property part is on
Ranjita
16.
Sodhuri.
Yes, ma'am.
Page number 16 is the FIR.
Yes, my lord, 16. Type petition 16.
The essence of allegation made in the FIR dated so and so is that the husband of the informant, namely Dr. Rajiv Sodhuri, was allotted one parking area in the flat Kingwood Tower, GMC Road behind Name Care Hospital, Guwahati. By letter dated 3/1/2024 and on 12/3/2024, while her husband reached the parking at about 3:40 p.m. on 11/12/2024, then on Ranjit Singh attacked her husband physically, and when Pawan Singh, son of Sanjeev Singh, attacked her husband with an iron rod with intention to kill her husband. And while she interfered, while she intervened, then Ranjit Singh and his son Rajiv Singh attacked her husband, severely attacked her husband to kill him. And they also caught hold of her throat and slapped her on her cheek, causing serious scars mark over her face and neck. And Rajiv Singh stolen away one of her Mangal Sutra from her neck. And Ranjit Singh also slapped her in front of several people and thereby outraged her modesty. Mr. Bora, learned counsel for the applicant, submits that the applicants are granted the privilege of interim PRS by order dated 19/3/2024, and thereafter the applicants had appeared before the IO and their statements were recorded, and they had been extending cooperation with the investigating agency, and therefore it is contended to take the interim order dated 19/3/2024 absolute in the same terms and conditions. On the other hand, Mr. B.B. Gogoi, learned additional PP submits that he has not received the case ID, but as per his instruction, the investigating officer had completed investigation and submitted charge sheet being charge sheet number
49/24 dated 28/4/24.
against all the accused persons.
Here not name, not mention, only search it number and date.
In view of the submission of learned advocates of both the parties, this court is inclined to dispose of this petition by directing the applicants to appear before the learned trial court and to apply for regular bail. And in the event of filing such an application, the learned trial court shall consider the same in accordance with law. Till then, the interim order dated so and so stands extended time.
21st June. Honor of the 29, item 29.
Mayor, please, Lordship. Lordship, 430 application, Lordship, opens under section 302 and FIR at page 9, Lordship.
302,
Yes, Lordship.
CD receipt,
CD receipt, my lord, with postmortem report.
is there any material?
Material, my lord, he along with other 2 person, my lord, came to the spot, my lord. And thereafter, my lord, one Sobur has beaten with a Sobure Bahor Kamire Deutak Agat Kore. That is, eyewitness is there, my lord. Main accused Sobur has already been arrested, my lord.
FIR also stated that, Lordship,
Hmm.
the prime accused Subur assaulted the deceased. Father of the.
Obor is the prime accused.
Prime accused, Lordship. And dispute, so far the land dispute is concerned, Lordship, it was going on between the Subur and the deceased, Lordship. FIR also reflected the same.
Heard Mr. A.P. Sarkar, learned counsel for the applicant, and also heard Mr. P.D. Gogoi, learned additional PP for the state respondent. Apprehending arrest in connection with Dhoguri PS case number 73 of 2024 under section 143 T02 IPC. This application under section 438 service is preferred by applicant Sahadot Ali for grant of PRS bail. The above noted case has been registered on the basis of one FIR lodged by one Taizuddin Sheikh on 11/3/2024. The sense of allegation made in the FIR dated so is that on 10/3/2024 at about 9:20 AM, one Sobur Ali, Sahadot Ali, Najibul Islam, Hasibul Islam, Josu Sheikh, Nazira Bibi, Ali Hussein, Safiqul Islam and others. On the instigation of Sahadat Ali and others, Sobur Ali were closing the road being used by the informant for coming out of his house. Then his father, Sunaullah Sheikh, inquired about closing the road from Sobur Ali. Then, as per direction of Sahadat Ali, Sobur Ali, being armed with a stick, suddenly assaulted on the neck of his father. As a result, his father sat down on the road, and thereafter the other accused persons administered blow with fist, and consequently his father got unconscious and fell down on the ground. Then, having seen the condition of his father, he raised alarm. And then the blazers came there, and his father was taken to Dhuburi Civil Hospital in an unconscious state. But the doctor examining him declared him dead. Declared him brought dead. Mr. Sarkar, learned counsel for the accused. Learned counsel for the applicant submits that. What is your submission?
So he's no way connected with the, because Sobur is not related to me. I am the villagers. And it is a land dispute between the Sobur and the Sunaullah Sheikh Lordship.
That the present applicant is no way involved with the offense alleged in the FIR, and basically it was a dispute between Sobur and Sunaullah. Sobur and Sunaullah,
Sunaullah Sheikh.
and that he is ready to cooperate with the investigating agency. And therefore, Mr. Sarkar contended to allow this petition. Whereas Mr. B.B. Gogoi, learned additional BP, has produced the case before this court and submits that the witnesses examined so far indicates complicity of the present applicant with the offense alleged in the FIR. Mr. Gogoi further submits that Mr. Gogoi, referring to the postmortem report, submits that the father of the informant suffered demise due to shock as a result of injuries sustained over the neck as described. And the injuries were antemortem and caused by blunt force impact. And that investigation is going on, and therefore investigation is going on. Only one accused has been arrested here in this case, and rest of the accused are yet to be arrested, and therefore Mr. Gogoi has contended to dismiss the petition. Having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record and also perused the postmortem report. Perused the case diary and the PM report. The PM report indicates that Sonaullah Sheikh suffered death on account of shock as a result of injuries sustained over the neck, and the injuries sustained by him were antemortem and caused by blunt force impact. Further, it appears from the case diary that the IO has collected sufficient incriminating materials to show complicity of the present accused with the offense alleged in the FIR. Investigation is going on, and extending the privilege of pre-arrest bail to the present applicant at this stage will hamper the investigation, and therefore this court is of the view that this is not a fit case where the privilege of pre-arrest bail can be granted to the present accused, present applicant, and accordingly the petition is dismissed. Case diary be returned. Published.
Item 37.
Make your lordship, which is a 430 application. That consenting relationship between a 19-year-old girl and a 20-year-old boy. Why don't we find the FIR at page 11? May I read the FIR, my lord?
Yes.
The informant respectfully begs to state that approximately 7 months back, I got to know the accused person through phone calls. The accused persons through phone calls used to make obscene gestures towards me. On 22/4/24, I visited my uncle's house, which is nearby the accused person's house. On 24/4/24, when no one was at my uncle's house, the accused took advantage of the situation, came to my uncle's house, and with the promise of marrying me, the accused person had sexual intercourse with me against my will. The accused persons also threatened to leak my private pictures and make them viral if I enter. Kindly see, my lord.
He may have something to submit
Yes,
in
lordship.
respect of these documents. Sorted, when you will be able to file?
Lordship in a week, lordship.
Sorted, not weak. Heard Mr. Esdas, learned counsel for the petitioner, and also heard Mr. Diener, learned senior government advocate
For one.
for the respondent number 126, and Mr. P.D. Bhuya, learned
P.D.
counsel
Bhuya.
for the
7 to
respondent
10.
number 7 to 10.
10.
The learned counsel for the respondent number 7 to 10 submits that he will file reply to the affidavit, additional affidavit filed by learned counsel for the by the petitioner. Here is and price for granting him some time. Here is accordingly allowed. Recessal is the matter on suggestion that
13. That's great. 13.
13. Yes,
Biplab.
13.
Well, as per your lordship's order, my lord, the case diaries are here, my lord. I
Ah.
have received the case.
Case there is shall be retained.